So, Chris, does a title insurer have a right to cure title if a defect arises and they're put on notice of a claim under a policy?
Yes, title insurance policies provide an insurer with a range of options for dealing with title defects and claims, including the right to attempt to establish title as insured under the policy, whether that's through negotiation or litigation. This is beneficial for a number of reasons, not the least of which is that insurers and the counsel that they're going to retain typically have specialized knowledge in real property law, and it can usually cure a defect effectively and efficiently.
When do these situations typically arise? How would an insured ordinarily discover there's a defect and put the insurer on notice of a claim?
Anytime a title claim or defect occurs is when an insurer's right to cure arises. One common scenario is when a title defect is discovered when a property is in the process of being marketed or under contract for sale. Under these circumstances, an insured owner will typically make a claim under its title insurance policy, and the insurer will seek to cure the defect. In these circumstances, as you can understand, the insured owner is typically eager to have title defect cured quickly in order to avoid a loss of the sale or any potential decline in the value of the property over time.
Why would it take an insurer some time to cure title? Why wouldn't that be a simple matter of just taking care of it very quickly?
Title issues are frequently complicated and often require a careful review of the record title by an experienced real estate attorney, sometimes going back many years, often many decades. Once a title issue is actually fully understood, other practical problems can arise. For example, if a party in the chain of title is required to give a curative instrument to correct an error or to give up an interest in the property, in those situations you've got to identify an individual, and that can be difficult. In other instances, that individual actually may be deceased, and you've got to identify and then locate the heirs in order to get the proper conveyances. If it's a corporation, the corporation may be dissolved or may have merged with another company. Under all these circumstances, the parties in a chain of title usually don't have any interest in whether title is cured or not, and for that reason are typically reluctant to help with your curative efforts absent some form of compensation or the threat of litigation. If litigation is required, of course, then it can take sometimes up to years to cure the defect.
What if an insured thinks that the insurer has simply dragged its feet and they haven't acted diligently to try to cure title?
If the insurer has in fact unreasonably delayed in curing the defect, it may be liable for the insured's delay damages. There are 5 scenarios under which this arises, and Florida law treats each of them differently. I know that you've had a great deal of experience with handling these types of claims, Mark. Can you get us started on the first couple?
Well, let me talk about one first, and that's a situation where an insured evaluates the claim and determines that it needs to file litigation to try to cure title. Sometimes, as you mentioned earlier, litigation can take quite a long time. In some jurisdictions, it can take literally years to establish title. It also depends on how vigorously the defense is in trying to assert another interest in title. In Florida, the courts have held that, consistent with what the policy says, it doesn't matter how long it takes if the insurer is successful in establishing title. In those instances, an insured does not have a claim that it took too long.
What if the insurer elects to file a litigation but is unsuccessful and the court determines that there's in fact a defect in title to the property?
If the insurer tries to establish title through litigation and is unsuccessful, then the policy says in those instances the insurer is liable for the difference in value between the property as it was supposed to be as insured and the property subject to the defect. Now, there's a little twist here, because if the insured is claiming that there was a delay, then the damages actually could be a little bit greater.
What other types of damages can be sought under title insurance policies in these cases?
If the insurer is unsuccessful in establishing title, then what would ordinarily be simply a calculation of the difference between the value as insured and the value as in fact, it becomes a little more involved, because let me give you an example. Let's say the property is worth $100,000 at point X, which would be after a reasonable time for the insurer to have tried to establish good title. And it's only worth $50,000 at point Y, let's say 2 years later, and the insured claims that additional 2 years was an unreasonable delay. If the court agrees that there was such an unreasonable delay and the insurer has failed to cure title, then the insured could collect that additional difference in value.
Are there any other limitations on liability under a title insurance policy?
The policy itself has a total amount of liability, and it states that that is the cap of any possible exposure of the insurer under the policy. So it's our view that even if there is found to be a delay through the litigation as I've described, that no event would that cap be exceeded. There is a decision out of Texas which purports to try to figure out what Florida courts would decide, and they've said there should be no cap in those circumstances. We don't believe that's correct, and no Florida court has yet expressly addressed that question. Chris, let's now talk about the other situations. You've also had a lot of experience with these cases. You said there are 3 more situations. What are those?
Sure. The third scenario is where the title insurer elects to file litigation to cure the defect, but then prior to final adjudication settles the case. The other instance is where there is an unreasonable delay prior to the insurer actually filing the litigation. And lastly, the 5th scenario is where there is no litigation filed at all and there's just an unreasonable delay in curing the defect through negotiations.
Well, Chris, would you tell us then about the first of those 3 and explain what happens when the insurer who's undertaken this attempt to cure ends up settling with a party as opposed to going through the full litigation and getting a ruling from the court?
There's no case law that's directly on point on that issue, Mark, but the existing case law, we think, would dictate the same result as in the case where the insurer files litigation and gets an order curing the title to the property. The result is the same in both instances, and the policy reasons for the protection of the insured are the same.
And then finally, we have those 2 other situations you described where an insured believes that the insurer did not pursue getting the title cured without litigation in a timely fashion, or where the insured contends that the insurer delayed before filing litigation. What is the situation there? Is there potential claims by the insured for those delays?
If the insurer unreasonably delayed in curing title in either of those situations, it could be liable for the insured's delay damages. Under either situation, however, there would still be the liability limitations under the policy, as well as the policy limits that would limit the amount of damages recoverable. And let me ask you a question, Mark, about the types of delay damages we've been talking about. Are they frequent?
Well, I'm happy to report that they're not. Ordinarily, title insurers are very diligent about processing claims. What insureds have to recognize is that, as you pointed out earlier, these really do take a lot of time. There are difficult legal issues that need to be analyzed, and to figure out what the problem is in the chain of title and to how to go about curing it can often take a bit of work and time. And as you also mentioned before, oftentimes you have to track down people, some of whom may have passed away, corporations have dissolved or merged. So fortunately, they don't arise very often, but sometimes they can arise.
How can an insurer avoid claims for delay damages, Mark?
Ordinarily, what insurers can do to try to avoid those claims is have a lot of communication with the insured about what they're doing and how they're trying to handle the claim. You would want to try to acknowledge the claim fairly soon after it's received by the company. You want to explain what you're doing, and then it's really important to document your file, because ultimately, if the insured feels things were delayed, it'll be very helpful to show how many times you tried to call somebody, how you tried to track somebody down, what your research revealed in terms of what the chain of title actually showed, where the heirs were, where the company went, and so on. So it's a process of trying to be prepared to demonstrate that what you did was in fact reasonable and diligent under the circumstances.